So, pleased to welcome Nima Rohani, who is a partner at McConnon Beyond. What's the full name there, Nima?
McConnon, Beyond, O'Connor, and Peterson.
There we go. That's right.
It is a mouthful.
That's right. And in fact, the last time we met, you were actually the lead partner or principal. What is your official?
Yes, I'm the managing partner.
Managing partner. Well, congratulations. I've known Nima a long time. We're have friends, common friends socially as well. And so Nima's presented before, does a great job for clients. And actually right now he's actually working with a client of mine, getting their wills and power of attorneys done. And so Nima, I guess the first thing we wanted to talk about is just what, lots changed over the pandemic. What are you seeing in the law and in estate planning that's maybe different than like a couple of years ago?
Well, obviously, in the last couple of years, mortality has been on a lot of people's minds due to the pandemic, as you said, Travis. And so I'm seeing a lot more people come to me now wanting to do their wills that would not normally want to do their wills before, just because they're concerned with, COVID-19 and how that could impact them and their family. So, and that's a great thing. I mean, obviously, you don't want to be paranoid, but you want to be cautious and prepared. And I think doing a will, specifically due to the pandemic, is completely fine. That I've had a lot of people approach me wanting to do that, and I applaud them for that. With respect to the law, the law hasn't changed due to the pandemic. The Wills, Estates and Successions Act governs wills in British Columbia and what happens if somebody dies with or without a will. There has been no amendments to the act that I'm aware of in the last couple of years. The pandemic hasn't changed anything with that. So in terms of the law, that stayed the same, but there's definitely been an uptick in the amount of people getting their wills done. And I think that that's great. Like I said, regardless of the pandemic, it's still always a good idea to get a will to ensure that your assets are transferred to the appropriate beneficiaries that you want those assets to be transferred to upon your death. So yeah, it's been business as usual, more or less, but there's been more people getting their wills in the last few years.
Okay. Yeah, great. And then maybe we could just, you touched on it briefly, but this is always a good thing to bring up is, what is a will? Like, why is it important? And then I know simple, but I think we would want to highlight that. And then, what is a power of attorney and why is it important?
Right. So a will basically sets out what is going to happen to your assets when you die. So who is going to manage your assets and who are the assets going to go to? Now, it's really important to have a will because if you don't, the Wills, Estates and Successions Act sets out what will happen and where your assets will go if you don't have a will. So, if you don't want someone specifically to get part of your estate, it's very important that you draft a will to ensure that that asset does not go to them, as the Wills, Estates and Successions Act may say that it goes to that person. For example, if you die without a will, the first $300,000 of your estate goes to your spouse, and then the balance is split equally between your children and your spouse. Now, in a scenario where people may have a blended family, you may want to have a will done to say that, well, the assets that I brought in, as part of my second marriage, I want those to go to my children and not specifically to my spouse. And that's fine as long as both parties agree to that. But if you die and let's say you only have $300,000, all of that is going to go to the new spouse, and your children will get nothing. And I've seen scenarios where that happens, and the spouse then doesn't give anything to the children from the first relationship. The spouse then leaves, and then the children are left with nothing. So always really important to get a will specifically for blended families. Another really important reason to get a will is to determine what should happen to your minor children if you die. Now, if you're married or common law, or perhaps you split, from your children's other parent, you're going to want to consider who's going to be the guardian of those children. If you're with somebody, let's say you're with your spouse or common law partner in a car, you both get into an accident and you die and you don't have a will, well, then the court's going to determine where the kids will go. So that can be a pretty scary proposition for people, especially if, like, let's say, for example, you have grandparent or the children have grandparents, but those parents are not, or the grandparents are not suitable for watching those children. The court may say, without knowing any of the background, the court may say, well, no, they got to go stay with the grandparents. And then, the children might not be in a good situation that perhaps you'd want to make sure that the children's guardians are your brothers or sisters or their aunts and uncles. Really important. Another thing that it's really important is I've had people come into my office and I ask them, who do you want to be the guardian of your children? And one person will say my parents, and the other person will say their parents, because they haven't even discussed it yet. And then you get into a big fight over that. And then, if they don't have anything in their will that would govern who the guardian of their children is, but they've told their parents that that's what's going to happen, then you have two sets of grandparents arguing over who's going to look after the kids. And obviously the only people that are harmed in that situation are the children. So really, really good idea that if you have children and you're a young family, you come get a will to set out who your guardians are going to be. And then, of course, just sort of the basic things that have to do with wills. Like, let's say you have a family heirloom and you want to make sure that gets passed off to somebody specifically. If you don't have a will, that's not going to happen, or there's a good chance that it won't happen. So always a good idea to have a will so that your wishes are specifically spelled out. The person who is going to manage your estate is specifically spelled out, as that might not be guaranteed either if you don't have a will, and that the assets go to the right people.
So Nima, one thing I've heard, and just maybe this, if you're in a car accident with your spouse, the younger spouse is deemed to die second. So the older spouse dies first. That's
if you don't have a will.
Okay.
Like, you can write in certain provisions in the will that says if you die within like a certain period of time of the other person, that basically, like, let's say, for example, you have two people, older spouse, younger spouse, they're supposed to give their assets to the surviving spouse if they die, but they both die together. Sometimes what we'll say is that if the other spouse dies within 30 days, then they're not actually to receive anything. It's just to go, basically, what would happen. Basically, you set out what happens if that person is not alive when you die, if they predeceased you, so to speak. So yeah, I see what you're getting at. If you die without a will, and it goes from and you're the younger spouse, and your will says something completely different than what the older spouse's will says, then your assets could potentially, the older spouse's assets would transfer to the younger spouse's estate, and then the younger spouse's estate could be dispersed in a completely different manner. So yeah, really, really good reason to have a will is for that reason that you suggested.
Or even the point where you don't have a will, everything's in joint, so it rolls from on death, really, the older spouse, it goes to the younger spouse, and then they don't have a will, so it goes to all their beneficiaries, and the older spouse's beneficiaries get nothing. So
exactly, yeah, exactly.
Okay. So one thing I wanted to comment on was just dealing with a lot more folks who weren't born in Canada. So they came here from other parts of the world. How does it work with assets that are held, like, say, in England or they're held in the US? If they've got a Canadian will, what does that look like? Do they get named? Like, maybe just explain some of that.
Great question. So I can't necessarily comment on, it's difficult for me to comment on that, just because every jurisdiction's laws surrounding death and wills and estates are different. So I don't know what the laws say in England, for example, but I do know what it's like if you have a will in England and then have assets in BC, but no will in BC. And I think, based on my knowledge, because I've obviously had to deal with this a few times, that it's roughly the same process. So if you have, let's say, one will in one jurisdiction, typically what you would have to do is file that will in the other jurisdiction. So let's say you have a BC will, but assets in England. you would go through probate in British Columbia, and then once you go through probate, you're supposed to send the grant of probate along with the will to someone in England who's going to manage the estate over there, and they would have to do what's called the resealing of the grant. And what that means is you would give it to their governing body that determines how estates and wills are verified, and then they would reseal the grant. And assuming that the will is valid in that jurisdiction, then whatever you say in your will in British Columbia would then be followed in England as well. So that's generally how it works. Cross province. I actually cross border as well in the United States. I had a client that had a California will, and we had to get some assets, some British Columbia assets, out to the beneficiaries in the States. They got probate, or I can't remember what they call it in California, but it was basically the equivalent of getting grant of probate there. They sent us over the grant of probate. We filed it here in British Columbia. We had to go through a couple of hoops with that to verify the will. But once we did, the grant was resealed here, and then we were able to sell their properties that they owned in British Columbia, get the net sale proceeds, and then deposit them to the lawyer in the trust account for the lawyer that was representing the deceased's estates in California.
Is there possibly double probate being charged? So we charge probate on the asset over there, and then they charge probate as well when they reseal the grant?
It really depends on the jurisdiction, Travis. It could. That's very possible. I know that it would be charged in BC. I think what happens in that scenario, though, is if it was cross-border, you would only be charged, probate fees for the assets that you hold in British Columbia. I don't think that I'm trying to remember that California file. Like, we definitely didn't have to pay probate fees for the California assets that they had. It was really only the BC assets.
Okay, so one thing that we talked about blended families and seeing more and more of this now. So what if you've got spouses and they say, like, well, we've got this house together, we've got a bunch of assets, and really we have enough money so that if we both live, like, we got enough money for us to take care of it, and whatever the kids get, they'll get, but we still want each of our families to kind of get what is rightfully theirs. How do you protect somebody so that, like, the one spouse may actually need some of the assets of the other spouse? How do you protect the families? Like, is there like a remainder trust, or like what kind of happens if you've got a mixed family, but you want the spouse to enjoy the benefit of the communal assets until they pass away?
Yeah, so great question. So there's a couple of different ways you can do that, but the main way, and I think really what the big asset is the principal residence. Okay, so let's say you have one spouse that separated from their wife, that matter is completely cleared, and then that spouse owns, let's say, a principal residence now fully in their name. They then enter into a new relationship. And either get married or they become common law. And over time, that new common law partner contributes to the principal residence. Obviously, that they're going to have an interest in the property then, but they weren't the one that paid for it. And that the first spouse wants to make sure that principal residence goes to their children, but they also want the spouse to then, be able to live in it. What you would do is you would create what's called a life interest in the first spouse's will. So what that means is on the death of the first spouse, the property title would transfer into the name of the beneficiary. So let's say you have one child, you would transfer the title into the name of that one child. But at the same time, you would register a charge called a life interest on the property in the name of that second spouse. So what that means is the beneficiary owns legal title, but there's this charge on the title called a life interest. It's just like a mortgage. Like, how you register a mortgage on title to secure the bank's interest for advancing the money. The life interest there is to secure the second spouse's ability to live in the property until they die. So because of that life interest, the beneficiary can't go and sell the property, because obviously whoever, is buying the property isn't going to want to buy it and then, allow that person, the person who holds the life interest to just live there for free. So, well, I mean, maybe that would seem a bit weird for me, but I guess that's possible, but I've never seen that. So basically what would happen is that second spouse would live there, during their life. And then once they died, you would just have to register a death certificate at the land title office to show that person has now died. The life interest would then be removed, and then the child would then be able to sell the property.
Okay, great. No, that's great. Appreciate that, Nima. Now, what if you've got a child or a grandchild that's disabled, and so what are some things you can do to maybe leave a legacy for them, or even just like let's talk about disabled grandchild or child, and then afterwards we'll talk about leaving a legacy for a grandchild. So let's just talk about, you've got a disabled child. What does that look like in terms of estate planning?
Yeah, so it's quite common that people will set up trusts for their disabled children, and they're called testamentary trusts or discretionary trusts. Now, what that means is your executor of your will, and that's the person who essentially manages your estates and disperses the assets to the beneficiaries, would take the portion of your estate that you want to go to your disabled child and put it into a trust. What that would mean is after the estate is settled, the executor then switches hats and they're now the trustee of that testamentary trust. And, I have pretty standard wording in my wills for the testamentary trusts. They're not usually too complex. Essentially what they say is that the trustee / executor is able to manage the trust funds, in accordance with the trust, basically, to ensure that the trust funds are protected, and then release funds from time to time to the disabled child to pay for healthcare, living expenses, education, healthcare, etc. So basically what would happen is they would just release funds in accordance with what the disabled person needed. Depending on how disabled the person is, they might have a guardian for them. The guardian would approach the trustee and ask for funds. The trustee or the guardian would furnish receipts and say, this is how much, we need for their health care. If they're under the, if the government is managing the affairs of that disabled child, the government would approach the trustee and ask for funds to pay for their health care, for example. And that trust would simply last indefinitely unless there was some end date on it, which would be set out in the will, and the funds would then be released directly to the child at that time.
Okay. No, thank you, Nima. Lots of people want to taking care of their loved ones, and that's a good point. Maybe you could just go over some of the cases that you've been working on and some of the estate stuff that you've been seeing, and just a couple of the recent examples, like, hey, this is kind of interesting, or I never thought of that, and some of the folks on here might find interesting in the way of estate planning.
Well, we were talking a little bit about cross-jurisdiction issues, and one thing that's really important is that if you have, let's say we were just talking about the trust here, for example, of a disabled child. I was working on a file, I believe it was last month or 2 months ago, where the will maker was in British Columbia and was residing in British Columbia full time, but they had a lot of their family was in Australia, and more specifically, they had a grandchild in Australia that was disabled. Now, they wanted to set up a trust for that disabled grandchild, and that was completely fine. But luckily, I had the foresight to realize that, well, hang on, the trust rules in Australia could be completely different than the trust rules here in British Columbia. So I advised the will maker to seek legal counsel in Australia for how to set up this trust. And I was correct. The trust procedure for a disabled person in Australia is completely different here. So it was great, because what happened is the lawyer in Australia basically sent me a 5 or 6 page letter basically saying exactly what I need to consider when I draft the will. So I took, you know, that letter and their recommendation and their advice and crafted specific wording that said, you know, basically what happens in the event that the will maker dies, and then this trust needs to be created for this grandchild. There was really interesting rules that we don't have here, you know, in terms of, you know, the value of the trust and how it's taxed. The fact that it's a trust made out of a will and not an actual trust that's made when the will maker is alive. All of those factors came in, and all of that needed to be considered. For example, if at the time of the will maker's death, if the amount of trust funds was over a certain threshold, it was going to be taxed at like a significant rate. And so basically what we had to say is that, well, if the amount of money is over this threshold, then basically we're only going to put the maximum amount in the trust, and then whatever's left over was dealt with in a completely separate way. So I thought that was really interesting. I had never done anything like that before. And it sort of just, you know, it was a really good exercise to understand that every jurisdiction is different. And if people want to give assets to somebody out of province, then you really need to consider what the rules are in that other jurisdiction before you draft the will. Because the last thing that any lawyer wants to do for their client is draft a will that will then end up being invalid if it has to go to another jurisdiction. So really important to get that good legal advice and take your time when drafting a will. You want to make sure you get it right the first time.
So I actually have another question. A lot of lawyers are retiring or maybe passing away. You know, a good lawyer never retires; they just keep on working. But what happens to their files? Like, what happens if you're like, hey, I was dealing with this lawyer, and now they're no longer here; they've retired. Like, what happens to the, like? Usually lawyers keep the original wills in there, like they're safe. So what happens in that situation?
So I can't speak for every firm because every firm has a different practice, but the practice at our firm is basically we would send a letter to the client and say the responsible lawyer on your will has died. The new lawyer that has taken over their file is, let's say, for example, it's me. So they would say Nima Rohani is now the lawyer on your file. We would like to give you the option to go to, you know, because of this, would you like to stay with Nima, or would you like to take your will file, or would you like us to direct it to another firm? So you basically give them those three options. And then depending on how they respond, we would act accordingly. So that's sort of how it works. Now that's with respect to the file. Lots of times people will actually appoint a lawyer to be their executor. Okay, and it's really no different than if you appoint a friend to be an executor and then they die. At our office, what we do is we do not actually appoint a lawyer directly. What we do is we appoint the firm to be the executor with direction to be, you know, to be that lawyer. So, for example, my wills say, the wills that I draft for my clients, if my clients want me to be the executor, they say, the executor is McConnell, O'Connor, and Peterson, and if Nima Rohani is still alive or working there, then we would like him to be our executor. So that's how it works at our firm. Every firm is different. I've definitely gotten wills where a lawyer directly has been appointed, and it's been a nightmare because, like you said, they've died, because a lot of people make their wills ages ago and then don't look to update them until it's too late. And now, you know, you're scrambling and have to go to court to apply for a new executor.
So I had a client, and she had named her old lawyer, who's now retired, as her power of attorney, and so he's retired, and so he became the power of attorney, and then he realized he couldn't charge because he was retired to be the power of attorney, and it became a big headache for him, and he actually discharged his services to the BC, I don't know, there's some organization,
Public Guardian and Trustee.
Public Guardian Trustee. And so that's something to think about too, is that, you know, if you're naming like a lawyer at a firm to be your power of attorney, and then, you know, 20 years pass and they retire, they may not want to do it, and then you have somebody else doing it. So it's good to have some kind of thing set up in that regard.
Yeah, and you know, that's a really good point, Travis. We actually don't, you know, in very rare circumstances will a lawyer here be appointed as the attorney. We usually don't do it sort of for the reason that you suggested. It can be a lot of work, and you know, we're not, it's not like we're opposed to doing it, but if we're going to go and do work like that, day to day, we charge our hourly rate for that. And it's, we got to go pay your $50 TELUS bill. That takes me half an hour. My hourly rate's $300. You're going to pay me $150 to pay a $50 bill. It's just not really, it's just not a good use of those resources. So because of that, it's usually not advisable to appoint a lawyer or professional to be an attorney.
And yeah, that's a really good point. And we actually there are organizations that are professional power of attorneys, and so they have systems in place, and they automate stuff, and they can do it. And so there you go. And this is a real issue now, because a number of my clients don't have kids, and then they also all their friends are their age, or their siblings are their age, and so if you're the last one living, who takes care of you, right? And so this is a conundrum that's happening for folks in their 80s, and they're also feeling a little bit scared, like, who is gonna look out for my well-being? And so we do have some resources in place. There's an organization called Concentra that can be a trustee on that type of stuff. And so we can take care of you in that regard. We're coming up to half an hour. Maybe we'll cover one more topic, and then if there's anybody who has questions, you can email them to me, or we have a Q&A here. And so I'll just tell the story of my grandmother, who was battling dementia, like worried about people stealing her diapers and like this type of thing. And so I've used all her insulin up once, and then ended up in the hospital. And then they deemed her not fit to live on her own. And so she was going into assisted living, and she had a condo, and like there just wasn't enough funds to support like keeping this condo empty and to pay for her government assisted care. And so she didn't have a power of attorney set up. And so they were kind of at a conundrum. We're able to go to a lawyer and get, the lawyer deemed her capable of like appointing my aunt to be the power of attorney, and they're able to sell the condo. But if they weren't, they'd have to get a commentee. And so maybe you could just speak about that case and what that looks like.
Yeah, so comiteeship, that happens basically if you become mentally incapacitated. And again, you don't, like you just said, you don't have somebody with that has a power of attorney for you. So very stressful, very expensive, really not a pleasant experience, especially if you have multiple people that think they are the ones that should control that person's estate. Like,
right,
like in a scenario where maybe the person doesn't have any assets, it's the opposite. You don't have anybody that wants to do it because
no thanks. Yeah.
Right. But I've seen scenarios where, you got a millionaire, multi-millionaire, tons of assets. Maybe they got into a car accident. Now they're mentally disabled, can't make their own decisions. You have people coming out of the woodwork to be their committee so that they can get control of their assets. So really, really scary when that happens. And, obviously the more value in the estate, you might have more people coming out to do it. And if the more people that are applying to be the committee, the estate pays for all of that. So it could be really, really expensive if people are fighting over that. So really, really good idea to have a power of attorney, especially as you get older, if you're worried that maybe you have a history in your family of let's say like Alzheimer's or something like that. It's a good idea to have anyways, because you never know what can happen if you get into an accident or something. But yeah, it's a long process. It can be a battle if people are fighting, and it's really expensive. So not a good idea. You really want to avoid that at all costs.
Okay, we'll open up for questions. And if no one has any questions, I actually do have a question in regards to business owners. I deal with a lot of business owners, but does anyone have any questions? Maybe we'll just open up for questions. If not, so what happens if you've got a business, shares in a business, and you've sold the business and now it's in a holding company, and you own shares of your holdco, the opco is gone, there's money inside the holding company, and you and your spouse both pass away, but list your kids as the beneficiary for the shares in this holding company. What happens tax wise? Like when both the spouses pass away, like let's just go over that scenario, because I think people just think, hey, they'll get the shares of the business and there won't be any tax liability. But my understanding is that when both spouses pass away, any shares in a business, there's quite a tax that, you know, anything that's in there has to be, you have to kind of reset the tax basis on it.
So I'm not an accountant, Travis, so I can't necessarily answer a lot of the in-depth types of tax questions. But what I can say is that when you die, your assets are valued on the date of your death. Okay. So let's say, you know, you sell your business for $100K and now you have $100,000 in your holding company's bank account, and, you know, your shares then go to your children. Mm-hmm. Those shares, again, I don't know exactly how the valuation works, but let's say the shares are valued at $100,000. You would then have to pay probate tax at approximate rate of 1.5% on the value of that $100,000. So $1,500 of that would be taxed for, you know, as probate tax, and that would need to be paid prior to the court verifying the will. And then once that's verified and the probate tax is paid, then the shares can be transferred into the beneficiaries. The beneficiaries then have the ability to access the funds, and depending on what the accountant's advice is, they can withdraw it all, or they may want to withdraw it over time, you know, to avoid any type of tax consequences.
Gotcha. We have actually a question. I've got feedback that the Q&A is maybe not working. So if it isn't, send me an email. I'll ask. I'm checking my emails. I've got a client who, one of her daughters lives in another province, and the question was, well, what if I name her as my executor and I pass away? Can the executor live in another province?
So, yeah, of course, anyone can live anywhere. You know, it's not like the will is invalid or a power of attorney is invalid if the executor lives or the attorney lives somewhere else. But you have to weigh the practical application of how that's going to work. With the executor, it's not as bad. Like, let's say you just have a couple of bank accounts in a principal residence. More or less, the executor can probably do everything from where they are. They wouldn't necessarily need to come to Victoria to like meet with me or whatever. If I was, you know, representing the estate, I could send the documents over to them where they are. They might need to get a couple of the documents notarized, so they'd have to meet with a lawyer there, or they'd have to meet with me over video conference call. It is a little bit more of a hassle, but it can definitely be done. But in terms of power of attorney, I definitely advise against appointing somebody as an attorney outside of the city. You know, when your power of attorney, there could be a lot of day-to-day things that you might have to do, and you might have to be actually in the city of that person in order to do those tasks. It's just, you know, really inconvenient to have an attorney outside of the city that the person lives in. But I mean, it can be done. I've seen it done before. It's just very difficult. So, you know, to answer your question, yes, legally it's totally fine. Practically speaking, there may be a lot of challenges.
Okay, excellent. Thank you, Nima. Yeah, please keep the questions pouring in. So this is a question I get all the time. It's like, well, my will's 20 years old. Nothing's changed. It's like, it still goes to both kids, you know, like if I pass away or my wife passed away. In that case, should you be updating your will, or is it fine to leave it? Is anything really changed? And like, would the will be invalid because it's old, but nothing's really changed in terms of the division of the will?
Yeah, so good question. Now, one thing to consider if your will is really old and you have kids is, do your kids have kids? Do you have grandchildren now? Because typically what would happen is let's say you made your will when your family was very young and, you know, your kids were a couple of years old. You know, and then like you say, basically, if my spouse and I die, or when the last of my spouse dies, everything is to go to my children equally. Now, in the scenario where one of those children predeceases the other child, you may want their share, that, you know, from child one that predeceased, to go to child two. That makes sense because there's nobody else for it to go to. However, if you have grandchildren, maybe you want the first child to what they were going to receive to actually go to your grandchildren of that child instead of the surviving child. Because what could happen is if you don't update your will to say that, well, then your grandchildren are going to be completely cut out from the will. They're not going to get anything. Everything would go to the second child, and depending on the relationship of the children, that second child may not give anything to their nieces or nephews. So that's a really good reason to want to come and update your will, because I do wills all the time for young families, and that's one of the questions I ask them is, if if one of your child predeceases you, do you want their share to go to the surviving child? And they, 99.9% of the time they say yes. And I say, just, consider, in the few years, if you ever have grandchildren, you may want to change that. And they always are like, oh yeah, good point. I don't want my grandchildren to get cut out.
Excellent. Thank you, Nima. That's a great point. And just another question come in. The question is choosing a power of attorney. So what should you consider when you choose a person for your power of attorney? They've heard problems that when that person is looking after your affairs, that they're not looking in your best interest. So I guess it's like, what do you look for when you're choosing a power of attorney? And then what legal protections are there for people if that power of attorney is acting inappropriately?
So yeah, great question. So really the most important thing is the person's got to be honest and trustworthy. You have to trust them. You have to be, you have to know that they're going to manage your assets. There's really no like foolproof way to ensure that they're going to manage your assets in accordingly. Well, but what you can do is you can appoint multiple attorneys. So if you're worried that the person you're appointing may act not in your best interest, you could appoint another attorney to act together with that first attorney. And you can do that with as many people as you want. Obviously, it gets a little silly or redundant if you're appointing more than, like, let's say 3 attorneys, because then it's just, it's a bit, it's not necessary. But yeah, I sometimes have people appoint 2 or 3 attorneys, and they have to act together. They all have to sign documents together, or like checks or payments out. They all got to sign it together to make sure that the funds of that individual are not being abused. Of course, there are some practical challenges to that, like getting everybody to sign something. It could take a while. It might just take a little longer to move things along in that scenario. But if you're worried about people perhaps abusing your estate, if you're mentally incapacitated, then you're going to want to appoint attorneys to act together. Okay. Now, so I think that probably answers that. Now, in terms of what happens if you only have one and they abuse it, I mean, if nobody ever realizes that the funds are being abused, then really there's no governing body that checks it. Like, there's no checks or balances there. But hopefully you have other family members or other beneficiaries that are going to receive that money eventually, and so they might be paying attention to what's happening. And in that scenario, if they feel that the attorney is abusing the funds, they can apply to court to remove that attorney and perhaps even sue them on behalf of the deceased, or excuse me, on behalf of the mentally incapacitated individual, to recover those funds that were spent inappropriately.
The kind of a nightmare scenario. You kind of worry that your funds are going to be taken advantage of. I have had, and then not on, they've had clients where it's like, well, mom is in palliative care and she doesn't have much to live, and so we want to distribute funds outside the estate so it doesn't go through probate. And I've had some power of attorneys write a check to distribute funds, and I'm not really sure what the legality of that is and how that looks. So maybe you can comment on that as if someone's distributing funds out to all the beneficiaries before someone passes away.
Yeah, that's not good. I mean, you can't, I mean, unless there is some direction, some letter or something that, to the attorney from the person who created the power of attorney while they were, mentally, sound, to say to do this, that's not allowed. I mean, that's that person who's distributing the funds could get sued. Now, practically speaking, let's say in a scenario where the person is doing this and they're actually following along what's in the will anyway. So the beneficiaries
this is where I've seen it, where it's like, okay, there's 3 siblings, each of them, we just, there's $50,000 in the account. We're just going to write each sibling a check for $100,000.
So
As per the
so in that situation, I mean, like, who's going to sue them, right? Like if the beneficiaries are getting the money, then who's actually losing out here? I mean, obviously, if the person whose money it is now doesn't have any money to live, that's really, really unfortunate for them. But if there's nobody to protect them or nobody to sue them, I mean, there's really not much is going to happen. It's possible that if the public guardian and trustee caught wind of that, they could then sue the attorney. But I don't know how they would find out. I mean, if that person's if that person was in a home that was run by the public guardian or trustee, and then the checks started bouncing and they're not getting paid, then they might look into it in that scenario. But really, if they're not notified and nobody's suing the estate or suing that person's estate, then I mean, it's nothing's going to happen.
Right. Oh, we got another question coming in here. So, the question is, how can you differentiate between a power of attorney, a representation agreement, and an advanced healthcare directive? Are they all included in the making of a will, and what should I expect to pay for each service?
Yeah, it's a great question. So it's important to understand that a will is a document that deals with your assets after you die, and a power of attorney and representation agreement deal with your estate and your assets and your healthcare while you're alive. So you don't need to have all three done together. I have clients that come to me just for wills, just for powers of attorney, just for representation agreements, or a mix of all three. I obviously advise that you get all three done so that you're fully protected. And the cost, depends on how many you're doing. Now, I will say that our firm has a great relationship with Island Savings. There's going to be a shameless lawyer plug here. Our firm has a great relationship with Island Savings for over 45 years, and we provide all Island Savings members with 25% off of our standard fees for wills, powers of attorneys, and representation agreements. So I'll give you our normal cost, and you could apply the 25% discount. The fee for a will is a fee for one will is $500. If you're doing it with your spouse, then it's $800. Power of attorney is $275, and a representation agreement is $275. And then if you're an Island Savings member, you get a 25% discount on all of those. Please note that those are the fees, though. Those aren't the taxes or disbursements. I can't give discounts on that. That would be added on after the fact.
We got one more question, and I think we'll end on this question, because we are pushing our time here, and I want to respect everyone's time. So the question was, how do I determine, and I'm going to answer part of it, and I'll send it over to Nima. So how do I determine between using a lawyer, a notary to make my will, or can I do it myself using an online will kit? So I will speak to the online will kits. Typically, you're making, pretty big decisions, and there's big money involved. And so the small amount that you're going to pay a lawyer to make sure everything's right, and just like when you pass away, it's going to be devastating for your beneficiaries typically. And so I would just pay a lawyer to do it. And this is my take. The difference between a notary and a lawyer, oftentimes they charge the same for the work. So and fees differ between firm to firm. So not every lawyer charges the same, not every notary charges the same. And so you'd have to just compare like what value you're getting and what their experiences are, and are they an expert in this area, or are they just kind of doing over the set. So some notaries do this notarized documents. And so but Nima, what is your take on things?
So just for the online DIY will kit, I've never seen one done correctly. Never one time. I'm not even saying that to like try to get work or anything. I've honestly never seen one done correctly ever. People don't understand that wills vary from jurisdiction to jurisdiction. And so I've had someone die, a client die. They didn't use me for their will. Their executor comes and gives me a will that they made. And the will was for California. And they don't have a single asset in California. It's all BC, and it was just completely done incorrectly. And I'm just like, this isn't gonna go through probate. Sorry, we can't do that.
Yeah.
There are really, really strict witnessing provisions in British Columbia for wills, and those the DIY kits always mess up on the witnessing. So sometimes you might have an executor witnessed the will or the beneficiary witnessed the will, those invalidate their gifts. Or any payment to the executor. So that could just be absolutely devastating as well. Especially if the wills, if there's a risk that the will could be contested. So, I mean, if you really want to save the money, go ahead, but I've never seen one done correctly. I honestly have not. In terms of, and sorry, what was the second part of that, Travis?
Notary versus lawyer, what's the difference?
I mean, yeah, like I will say, I'm not going to like sit here and say a notary can't do will. Of course they can. I will say that for basic wills, I'm sure notary's fine. I don't think that they're any cheaper than me or any other lawyer. I'm sure it's fine. But if as soon as it gets if there's any complexity at all, they really can't. They really aren't. They're not knowledgeable enough to do it. They just weren't trained to do that. I'm not trying to knock on notaries for that at all. It's just the nature of it. I mean, lawyers go through a lot more schooling and a lot more training in order to get in a position where they can draft complex and sophisticated wills, and that's just the hard truth of it. So really, I obviously am going to advise that you go to a lawyer just to make sure you get all that you consider absolutely everything. But no, I mean, it's, I'm sure if you got a good relationship with a notary and want to go do that, it could work as well.
All right. Excellent. Now, Nima,
I see a question. I actually see a question on the Q&A. Someone said, where should you keep your will with lawyer at home or in a safety deposit box? That's a really, really good question. That's actually one of the things I go over with my clients within the first few minutes of them sitting in my office. So I say that they should definitely keep it with me at my office. It's locked away in a fireproof container. It's never, ever going to move. So you know exactly where it is and it's going to be safe and secure there. You can keep it at home, but just, if your house burns down or is damaged in an earthquake or something and the will's lost in that, then it's and then you die. It's as if you've died without a will because you need the original to go through probate. And then for the safety deposit box, that could be fine, except I've seen it lots of times. It's sort of like a chicken and the egg thing where someone dies and they know that the will is in a safety deposit box, but the bank won't let them into the safety deposit box because they can't prove that they're executor because the will is in the safety deposit box.
Right.
So you can't get in. You need the will to get in, but you can't get in because the will is there. So every bank is different. Some might be more relaxed with those rules. I've definitely seen some that aren't. So I would just say no, don't do that just in case. I mean, it really doesn't hurt to just keep it at a lawyer's office.
Yeah. And there's no charge to retrieve it. It's not like you guys are charging $10 to grab it. Yeah, absolutely. Well, Nima, thank you so much. I really appreciate your time. And I've said to clients, like, how often do you get to ask a lawyer questions for free, on my dime? And so to be here. So I really appreciate you answering those and covering some topics. Likely going to have you back again in the future if you're willing. So thank you for that. And if anyone does want to connect with Nima, needs some estate planning, like I said, we have a discount. He's working right now as we speak on one of my clients' wills.
We'll see him tomorrow, Travis.